Hello everyone and welcome to Law Chakra. As we know that all the 11 convicts in the Bilkis Bano case were released on August 15, 2022 after the state government allowed their remission applications. One of them, Radheshyam Shah, approached the Supreme Court in April seeking remission, arguing that he had spent over 15 years in prison in this case. By an order in May, a bench led by Justice Rastogi directed the state government to consider the convict's plea for premature release in accordance with the 1992 policy, the one prevalent on the date of their conviction. While the existing remission policy of 2014 of the Gujarat government prohibits the early release of rape convicts, no such restriction were a part of the 1992 policy. These 11 men were convicted in 2008 for the gang rape of Bilkis Bano, a 21-year-old and 5 months pregnant, and the murder of her family during the 2002 riots in Gujarat. After their release, visuals of them getting heroic welcome became viral in the social media, leading to outcry among several sections. After that, a bunch of PILs were filed in the Supreme Court questioning the relief granted to the convicts. Bilkis has also challenged the premature release of the convicts. A bench led by then Chief Justice of India N.V. Ramana issued notices to the Gujarat government and the convicts in August 2022. As this bench also included Justices Rastogi and Vikramnath, the matter was listed before Justice Rastogi's bench after the Justice Ramana's retirement. Gujarat government filed its affidavit on October 17th and disclosed that the Union Ministry of Home Affairs had approved the early release of the convicts, while the state government took into account their good behavior as a key reason to grant remission. In May 2022, a bench led by Justice Rastogi had ruled that the Gujarat government had the jurisdiction to consider the remission request as the offence took place in Gujarat. The review petition filed by Bilkis Bano seeking review of this decision was dismissed by the Supreme Court in December last year. But once again, the matter this year came before the Chief Justice of India D.Y. Chandrachud, who agreed to consider setting up a new bench, as Bano's lawyer pointed out that the matter was not heard since December after one of the judges on the designated bench rescued herself from the case. Under the Supreme Court rules, it is the Chief Justice's prerogative as the master of the roster to assign cases to different benches. A new bench in the Supreme Court comprising Justices K.M. Joseph and B.V. Nagaratna was constituted for hearing the said matter. The special bench said that it would apply a 3-point test, that is, first, the Mumbai Trials Court judge's opinion opposing the remission, secondly, the heinousness of the offence, and third, the release of the convicts when life convicts in other cases are languishing for decades. To determine the validity of Gujarat government's decision to grant remission to 11 lifers in the Bilkis Bano case involving gang rape and murders. During the hearing, appearing for Bilkis Bano, Advocate Shobha Gupta said that the Gujarat is not the appropriate government and that the Supreme Court has erred in deciding. Moreover, the gang rape survivor was not consulted by the Gujarat government before granting remission to the convicts. There are complaints of life threats allegedly issued by the released convicts, the witnesses, and the survivor and her family members fear of their life. The bench asked a convicts counsel, Rishi Malhotra, "What do you say about the total lack of jurisdiction of the Gujarat government? Can the Supreme Court, through its May 13, 2022 judgment, direct a body which had no jurisdiction to decide the remission? Even if it is palpably wrong, can the Supreme Court take a contrary view when the review plea against May 13 judgment is dismissed?" Malhotra said that the Bombay High Court as well as the Supreme Court had ruled that the Gujarat government was the appropriate government under Section 432 of the Criminal Procedure Code to consider the convict's plea for remission. He further said that Bilkis Bano plea for review of the May 13 judgment has been dismissed by the Supreme Court. The only remedy available to her is to file a curative petition, not a writ petition. Hearing के दौरान Justice K.M. Joseph ने पूछा that our experience is that many life convicts continue to languish in jails for more than 20 years. The Supreme Court had to ask the concerned governments to consider their remission pleas. What are the special grounds in this case? गुजरात गवर्नमेंट ने पिछले साल 10 अगस्त को गोधरा के बाद हुए कम्युनल राइट्स के मामले में कन्विक्ट्स को रिमिशन ग्रांट कर दी थी, जिसकी सुनवाई अदालत के आदेश पर गुजरात से मुंबई ट्रांसफ़र कर दी गई थी क्योंकि वे 15 साल से अधिक समय तक जेल में रहे थे एंड दे हैव रिपोर्टेडली शोड गुड कंडक्ट इन जेल. However, it had also stated that the trial court judge at Mumbai as well as the prosecuting agency, the CBI, had opinioned against the grant of remission on the ground that they committed the heinous offences in a gruesome manner. Justice Joseph had also questioned if the release of 11 convicts in the Bilkis Bano case was done according to the remission standards in other such cases. He asked, "We have before us many murder cases where convicts are languishing in jails without remission for years. Is this a case where standards have been applied uniformly as in other cases too?" To this query of the Supreme Court, it was informed to the court that the 2014 policy of the centre excluded those serving life sentences for heinous offences from the purview of consideration even after completion of 14 years of jail term. Advocate Malhotra said that the Supreme Court in a series of cases since 2010 has consistently ruled that the policy in force at the time of conviction should be applicable for consideration of remission pleas. In the hearing, the senior advocate Kapil Sibbal was also seen defending his client Subhashini Ali's locus standi. He said, "It is not an ordinary matter but of grave public importance. We are not seeking prosecution of anyone. We are challenging the process of grant of remission to these convicts, which was against the statute and complete non-consideration of the gravity of the offences. We are seeking laying down of procedure for fair and transparent consideration of remission pleas by the lifers after completing 14 years in jail." On the arguments by the convicts that they have already served more than 15 years when the life-term convicts are released after 14 years, Justice Joseph said that we are not going to be overwhelmed by emotions, have to strike balance. It is a horrendous crime. Advocate Malhotra and Sonia Mathur, appearing for some convicts, sought a longer time for filing their responses to different petitions. Justice Joseph posted the matter for hearing on April 18th. He also asked the centre and the Gujarat government to present all the relevant documents related to the remissions granted to these convicts on the next date of hearing. That is all for this video. Keep following us for more legal news and updates.